Yes, the pink stuff. Sorry, I had to have Moth grab me something to drink.
Okay, we are now live streaming. Let me go back to my Zoom room and let people in. Okay, good afternoon. First matter I'm going to handle today is Milling versus Gilbert. Mr. Berlinski?
Good afternoon, Your Honor. Brad Berlinski on behalf of the plaintiffs. Are you ready to proceed?
Yeah, I'm just checking to make sure nobody else just logged into the meeting room. Looks like the other persons here are for the other 3 o'clock.
Okay.
So,
Judge, this is a foreclosure of a land contract matter. The court entered default judgment in August. We went through the steps for the foreclosure. The attachments on Exhibit A are the various affidavits related to the foreclosure. The sale was conducted by Deputy Sheriff Hobbs November 18th. Plaintiff was the only bidder for a gross sum of $125,000, which is less than the actual debt. So there's no excess funds. We submitted a proposed order with the motion. Hopefully the court received it. We would ask that the court grant the motion and enter an order confirming the sale.
I'm looking through your motion. And all right, whoever printed it out for me didn't print out the order. But I'm assuming it's available. You know what might be easier? If you could just email your order to me.
Okay.
Was sign it, scan it, send it back to you and to the clerk's office. I and my staff are working from home this week because we had a COVID case in the courthouse that impacted my staff. So it's a little harder to get things filed from home, but clerk's office has been very accommodating.
Good. Yeah, I was wondering. I went to file some things on Thursday or Wednesday afternoon, and they said, well, the clerk's office was closed downstairs, and probate took some paperwork for me, and I was wondering how the other staff might be affected.
The whole courthouse wasn't impacted the same way. Depends on who you had contact with, and everyone in my staff had contact with someone who had direct contact with one of the persons who tested. They told us to stay home this week, so that's what I'm doing.
All right. Well, I wish you the best, and I'll send that email here shortly.
Okay, I'll watch for it. Have a good day, Brad.
All right, you too. Thanks, Judge.
Next up, let's see. Atkins versus Taco Bell. Counsel, could you each state your appearances, please?
Your Honor, Nolan Erickson on behalf of the plaintiffs.
Good afternoon, Your Honor. Javon Williams on behalf of Sundance, the correct defendant. I believe that Taco Bell was substituted out of this case.
Okay. This is your motion.
Correct.
So
Would you
I
like me to
have
proceed?
read
Judge, I think you froze on us for a second.
Yeah, my internet's not the best. We'll struggle with it. Get our way through. Go ahead whenever you're ready.
Okay, yeah, this is the date and time scheduled for defendant's motion for summary disposition. Briefly, by way of background, Judge, we have a premises liability action arising out of a 2016 incident. Now, the undisputed facts are that the plaintiffs, husband and wife, walked into the restaurant. They all went up to the counter to place an order, went to a table to sit down because they were going to dine in this day. And Rosette Atkins gets back up when the order is ready, walks up to the counter without issue, picks up the food for her husband and I believe her granddaughter, and is walking back to the table when this incident happens. Now, based on Rosette's testimony, here's what we know. When she was at the counter, she observed a bucket with water, dark water in it, which she described as what she thought was dirty mop water, and a wet floor sign sitting right up near the counter area. Now, she says the inside of this restaurant's not a very large area at all in the inside, and that after she sees this mop bucket with dark water and the wet floor sign, she's walking back to the table. The question is, were you looking at the ground as you were walking back to the table? Her response was, quote, "I have no clue," end quote. So as she's walking back, she takes 10 steps or so. I think she said within 10 steps, she slips and falls down. Once she's on the ground, she sees what she says is a dark substance all over the floor and on her new gym shoes, because they're, I think, white was the color of the gym shoes. And now she sees it as she's on the ground. Her husband, Gary, gets up from the table and is approaching her to go check her out after she had fallen down. Gary testified that, and we've cited this testimony for the court in our reply brief, which I trust that the court has received and read. Gary says, as I'm approaching my wife, I could see the substance on the ground. Neither one of them actually know what it was on the ground, but he says, I could see it. And the question is, well, is it a large area, a small area? What are you looking at as you can see it as you're approaching your wife? And he says, well, it was larger than a strip. Okay. Rosette testified, one, I have no clue if I was looking. Two, I can't tell you if I would have seen it had I actually been looking at the ground. So this is the undisputed testimony. What we have here is the C-10 motion for summary, and plaintiff's response to the motion would have been due within 7 days of the hearing. They didn't meet that deadline. They didn't file a response 7 days before the hearing. So that, as an independent matter, is grounds for the court to not consider plaintiff's response. But assuming that the court is going to go forward with the hearing, alternatively, summary disposition is appropriate because the alleged hazard was open and obvious. Now, we've cited for the court, again, in the reply brief, a list of cases that say if you're doing an open and obvious analysis, you have to at least look as part of this casual inspection. Okay, now we cited the Brooks case and I think two others that actually highlight, look, if the standard is an objective person and it's a casual inspection, you have to at least look. We have plaintiff's testimony where she says, I have no clue whether I was looking, and even if I were, I can't tell you if I would have seen this or not. Okay. The fact that she also saw this bucket with what she said was dark water, and she thought it was dirty mop water, and the wet floor sign within 10 steps of where she fell down makes this case also very similar to the other matter that we cited. Let me get the case name for Your Honor for that one. I think it's the Cameron case from 2007. Wherein I think the person said that they saw a wet floor sign and they fell down within 6 feet of where this was. And the court said, look, the general circumstances surrounding this incident would have put a reasonable person on notice to look at the ground, and you would have been notified of the potential hazard there. Again, you know what Rosette testified to with respect to whether or not she was looking, and if she was looking, what she would have seen there. There are no special aspects that would render this open and obvious hazard as still a hazard. We know what the cases say there, Judge, falling under Lugo, falling from a standing height. There's nothing unusual about that. There's no reason to think that someone would suffer severe and permanent injuries as a result of falling down from a height. So it's not unreasonably dangerous. The other proposed special aspect would be whether or not it was effectively unavoidable. We know what the examples say about that. Being trapped in a warehouse, one exit, floor completely covered by water, you have to encounter that hazard in order to get out. It's not what we have here. Rosette testified she wasn't trapped. No one forced her to go into the restaurant that day. They could have used the drive-through. They could have avoided the inside of the restaurant altogether. So that's the testimony. Alternatively, we have the notice defense in this case. Judge, and by chance, I read plaintiff's response. They cited the Slaughter case and the Watts case. Both of those cases are distinguishable from our case on the open and obvious front because in Slaughter, the plaintiff testified that she couldn't see the hazard before nor after she actually fell down. So that's different than what we have here based on Rosette's testimony. Watts' case, the plaintiff testified that I was looking at the ground and I still couldn't see the hazard. So in those cases, the court say, well, look, you're looking for it, you can't see it, therefore it's questionable whether an ordinary person would have been able to see it. That's different than a situation where someone says, look, I have no idea whether I was looking at the ground, and even if I were, I can't tell you if I would have seen this or not. So those cases cited by the plaintiff are clearly distinguishable. We've cited the cases that are on point for the court. As for notice, there's no evidence that my clients had notice of this alleged hazardous condition. So what do we know from the testimony in support of the C-10 motion? Rosette says she didn't know whether this was water or something else that was on the floor. She doesn't know where this alleged hazard emanated from, where it came from. She has no idea how long the alleged hazard had been present. She doesn't know for certain what time the restaurant opened. That goes to whether or not maybe this was something that another customer had done. I think she said they arrived there at around 11 o'clock that day, and there was further questioning. You know what time the store opened that day, around that time? And she said, no, I can't say for certain. So there's no direct evidence that my clients knew about this alleged hazard, no testimony to that effect. There's no indirect evidence that my clients knew about it. And you have to establish one or the other. Actual note.
Isn't it a mop bucket full of dirty water located 10 steps away indirect evidence that somebody knew about it and attempted to clean it up?
No, Your Honor, and here's why. One, we can't allow, under Skinner, we can't allow the juries to guess here. So we have the plaintiff that says, I noticed a bucket up near the counter that had what appeared to be dirty mop water in it and a wet floor sign up there towards the counter. Now, what she says, and also her husband says, is they don't know what this substance was on the ground. And I think they referred to it as a thick black grease at some other point. So no one has testified that this was for sure mop water on the ground, which is part of the issue. Is if my client, you can't prove that my client knew that something was on the ground there, how are you supposed to remediate it? You can't allow a jury to guess to say, oh, well, yeah, we think that it was mop water on the ground because that didn't come out during discovery, that indeed it was mop water on the ground. And also on that front, we've cited a case for the court, that's on the open and obvious front, where there was mop water. It was conclusive because I think an employee testified in the case cited that the area had been mopped. I think the plaintiff in that case or witnesses saw an employee actually mopping the area. It's very different than what we have here. And you can't allow that to go to a jury to guess whether or not this substance, which no one has actually identified, was mop water. So again, there's no direct or indirect evidence that my client had actual nor constructive notice. The case is cited by the plaintiff, I think, Berryman and Carpenter, they deal with very different facts where you can draw that conclusion. There was testimony to back it up in those cases. And plaintiff's position in this case is, look, I don't have to prove notice because your employees created the hazard. Well, that's just a statement in their response brief, but there's no meat on the bones, Judge. There's nothing to back that up. No testimony that my clients created this hazard whatsoever. So the case is cited by plaintiff stating that they don't even have to prove notice. Those cases are distinguishable. So for either of those reasons we set out, summary disposition is appropriate.
Thank you. Erickson?
Thank you, Your Honor. At the beginning of the hearing, when your camera froze briefly, you were about to explain what you had read to prepare for this, and I just wanted to understand and make that clear for the record before I start my response.
Supporting brief, the response, and then the reply to the response.
Okay, thank you, Your Honor. I want to address what I feel are probably the four key facts here in order. First of all, regarding the burden of proof and the stage procedurally we're at right now. We are questioning whether there's a genuine issue of material fact. And our burden of proof is merely more likely than not conclusively, not 100%, not beyond a reasonable doubt. Three key facts in this case are, first of all, the characterization of Ms. Atkins' testimony. When she was asked what she was doing just prior to the fall, here's the question and answer. It's from page 6 of our brief, Your Honor. Are you looking at the ground while you're walking, or are you looking ahead of you towards your husband? Answer, just watching what's around me and observing the area I'm walking in. So it's not exactly right to say that she has no idea about anything or that she's somehow being careless. She is being observant as a casually observant person would be. I think another key fact here, Your Honor, is the hazard that did cause the fall, which was described later as kind of a foggy substance, not clearly black or anything, was not visible until after she slipped and after her footprint or slide mark, skid mark, whatever you want to call it, created a contrast between the substance and the floor, whatever that substance may have been. The substance was also visible on her shoe, and I believe she testified on her clothing as well, much more along the lines of the Watts case that has been discussed and cited in both briefs. As for the issue of notice, Your Honor, that brings me to the third key fact in the case. That mop bucket does create an inference, or at a minimum, a question of fact regarding the notice available to the defendants. That mop bucket was either there to address something that they knew about or something that they either just mopped or they were just going to mop. The record isn't 100% clear, but so far the only uncontroverted, undisputable evidence right now is that our clients believe they were the first customers in the store at 11:30. This is before that particular Taco Bell served breakfast. That's the testimony there. I haven't seen anything to the contrary. Your Honor, I think the defendant's brief is very long on general, open and obvious law, very short on the specific facts of the case. I think when you look at, and it's our position that if you look at the situation that we had here where Ms. Atkins was being observant of her surroundings, maybe she can't say exactly what she was looking at the very instant she fell, but she was observing and watching my area where I'm walking in. Slips, does not see the hazard until after she sees the contrast that her skid mark created between the substance and the floor. For those reasons, it's not an open and obvious hazard. It was not visible upon casual inspection. Her husband Gary's testimony is consistent that he did not see it prior to her creating that contrast in the flooring and the substance. And as for the notice, Your Honor, again, the mop bucket creates, I believe, a very permissible inference where a jury could conclude that the defendants either caused the hazard, knew about the hazard, or were going to address the hazard. They had either just mopped or they were going to mop. And so far, as we know right now, they were the first customers in the store and nobody else could have created that hazard. Thank you, Your Honor.
Thank you.
Oh, go ahead. Sorry.
Anything further, Mr. Williams?
Yes, Your Honor. I'd like to, because this is a C-10 motion, Judge, and it's based upon the record and the evidence that was revealed during discovery. I appreciate Eric's recitation of what he believes happened here, but we have to actually look at the testimony, Your Honor. And what we did was we tried to condense these issues in the reply brief. Maybe at page 6, Rosette testifies generally that she was paying attention to her surroundings, there was a very specific question about whether or not she was looking at the floor. And if we look at pages 43 through 45 of her deposition transcript, we were very specific in what we were asking. And she testified, I have no clue, when asked, were you or were you not looking at the ground? The follow-up question to that was, if you were looking at the ground, if you had been looking while you're walking back to the table, would you have seen this substance on the ground? And she said, I don't know, I can't tell you that. So it's very different than the characterization that Eric would have the court believe. The devil's in the details. This is what she said. I can't tell you if I would have seen it had I been looking at the ground, okay? Gary also at pages 12 through 13 of his deposition transcript testified, look, I wasn't paying great attention that day. After my wife fell, I wasn't paying attention, but I was able to observe the substance covering this area that's larger than a strip as I was approaching my wife. So it's there. We know that Rosette says, I don't know if I was looking, and if I was looking, I can't tell you if I would have seen it. Then we have Gary at pages 12 and 13 of his death transcript saying, I wasn't paying great attention that day, but as I approached my wife, I could see it. As for the notice position, Judge, again, they have to prove actual or constructive, or to say that my clients actually created the hazard. Plaintiff's position here, if you read plaintiff's brief, is I don't have to prove notice at all because defendant created the hazardous condition. That's their position. They're stuck with it because that's what they raised in response. The problem with that is there's no evidence that my client created the hazard, okay? His position here today on the record is, well, maybe they had just mopped, they were going to mop. Where do you stop the speculation, Judge? Because there's no testimony from any employee that, hey, yeah, I had just mopped that area. There's no testimony from like the Berry case that they've cited where others say, oh yeah, I just saw that employee over there mopping in this very area. All we have here respectfully are the plaintiff's attorney's feelings about what he thinks happened that day. Again, the problem is there's no evidence, and this is a C-10 motion, it's the put up or shut up stage. There has to be some hard substantive evidence to that the Sundance employees created the hazard. I haven't seen it. I haven't heard it today. I heard a few suppositions about what could have probably happened. That can't go to his jury.
All right. Thank you, gentlemen. I believe that there is enough of a question of fact here that summary disposition. I think the fact that there was dirty water in the mop bucket is a pretty clear indication from, or at least from which a jury could infer that an attempt was made to clean it. You wouldn't clean a floor with dirty water, you would clean it with clean water. So certainly an inference is there that somebody in that store early in the day had a mop out, was mopping a floor. That mopping effort created dirty water, and we have a plaintiff who didn't see it on her first pass through the area, but slipped on it on her second pass through the area. It clearly wasn't obvious enough on twice passing over it. Erickson, you'll submit an order denying the motion?
Judge, we lost you for a moment there, right towards the tail end. I want to make sure that I have a clear record of what the judge was thinking on the open and obvious front, because that's where you went out, I think.
Yeah, and I'm not sure what you did or didn't hear. What I'd indicated was we have a mop bucket of dirty water. That creates inference,
right,
that somebody did something to make that mop water dirty. You wouldn't begin to mop a floor with dirty water. You'd get a clean bucket of water and put whatever cleaning substance in it. If it's there to clean, and I can't imagine why else there was a bucket sitting outside the counter, other than the fact that an employee must have just done something. You wouldn't leave that bucket sitting there for an extended period of time. You'd clean it up. I think a jury can infer that indeed an attempt was made to mop this area. The plaintiff passed over this area. I'm gathering 3 times from the testimony. Once when she went to the table to, again, when she got up from the table to go retrieve her food, and then the 3rd time as she was returning with her tray of food. It wasn't obvious enough that she noticed it during the first. And clearly, the uncontroverted testimony is that it was, and she fell on it. I think that's enough to allow a jury to infer there indeed was notice to the and there's a question of fact as to whether or not it was so open and obvious that any casual observation of the area would have revealed the risk. So Mr. Erickson, if you could please present an order, just simply for the reasons stated on the record that the motion is denied.
Yes, Your Honor, I will do that. Thank you.
Thank you, gentlemen. Have a good day.